Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Esiedu Entry, and today I'm having a fine gentleman. I'm sure all the Gen Zs have come to love him on X. He tweets and millions are just following, commenting and others. He's been very instrumental in our electioneering process through 2024 and now still instrumental. His name is Oliver Barker-Vormawor. Say, welcome to the Law Lab.
Thank you.
Right. Oliver is the senior partner of Melton and Everett LLP. It's a law firm and also a policy consultancy, right?
Yes.
Good. Today's video is proudly sponsored by Vian's Groceries. They are located at Paraku at Dome. If you need any kind of grocery, their contact is on the screen. So today we are discussing mainly constitutional provisions, as you've been drumming home that we need an amendment, in fact a total overhaul of our constitution. But before that, I'll pick your initial thought on some few things. A president is voted on the 7th of December. On the 10th of December, the Electoral Commission declares him as president-elect. He is not president yet. The only power he has is to, together with the substantive president or the incumbent president, form a transition team. All we hear is he's setting up a committee oral, and the oral team being mandated to receive information. Is that committee a is it constitutional? Is it legal?
So one of the things I find quite interesting about this country, is that a lot of conversations that are governance related or, politics have been lawified. That everything then is filtered through the prism of black letter law. Does ABC exist? And for therefore, whether or not your power is to do X, Y, Z. Now, the president-elect has no substantive powers to act as executive, as commander-in-chief. Okay. Right? They still have a president, don't forget. That president's term only ends on 7th January. So it's important then that when the president-elect takes actions, it is not based on any fountain of power. There's no law, or there's no, whether it's constitution or anything that gives a president-elect authority to do anything public. But they can still act as individuals. And in that regard, they can form an advisory committee to advise them. In the same way that they had an advisory committee to manage their campaign, they didn't need to be president to do that.
That's true.
They can also take a number of decisions towards their coming into office. One, have a group of individuals that advise them on economic decision-making, on budgeting, in preparation to be able to do that. So when the president-elect does that, we are not having a legal conversation. There's no question as to whether or not the Constitution sanctions or this doesn't sanction anything like that. It's the same frame that we have to think about oral. The president says that my flagship program is recovery of loot and prosecution of those who have been corrupt. He's entitled to advise a group of people to advise him on how he's going to do that. He's entitled to then interface with the public and say, send me ideas when I become president, how I should do this, right? And the same way, even any political party, whether or not you're in office or out of office, can set up a whistleblower program and say that anybody who wants to blow the whistle on what they're saying, bring that to bear. Now, in that regard, the individuals that are named onto a committee are not themselves acting in any public office, right? So what you have is just a normal process of, politicking, which doesn't, entail or call for law.
You see, the difficulty here is that, I agree with you perfectly, it has no legal or constitutional basis over here. But those group of people who have been sanctioned by a president-elect, myself, I can call some people together that advise me on this, and it is normal. But these people now put cameras on them, move to private people's, their properties, filming, casting aspersions, and others, you've stolen state land, probably it is true or not. You don't think that is where the conversation now stems out, that what they are doing is even legal for them to be doing all these things, and you don't think they are infringing on the privacy of these people? They took cameras to their properties.
Now let's be clear, even if it was a presidential committee, all those concerns around privacy still arise. So the fact that even if the president was president, qua president, had already been sworn into office, that the conduct of a committee that he appoints are not insulated from scrutiny for actions that they take, whether they are legal or whether they extend beyond what they're capable of doing, right? So in the same vein, if I point a group of people, even not as president-elect, right, and I ask them to investigate this thing for me, and they're going around with cameras, going to people's property, any remedies that are available to anybody can be brought against them. So the president does not get any particular immunity, or president-elect does not give the community any immunity, and anybody is entitled to take action against them. So it's still the same operation, that if he has appointed people, and people have been acting in ways that violate people's rights, those people are entitled to take them on. They don't. It doesn't stop that. You know what I mean? So the fact of he being president or not being president does not clothe them with anything, and for that reason, his actions or the actions of the committee do not entail the republic. For instance, if somebody is going to sue them, they don't sue the attorney general. They sue him and the president-elect that has emboldened them in his private capacity, as he will.
Unfortunately, the president would then, within some few days, jump into the position.
Jumps into the position. Your process becomes it's held in abeyance, right? It means that nothing can be done. You just wait
for some 4 years.
For 4 years, and you come back.
You do that. So you would agree with me that it is problematic that you are being called to serve on a committee, and all that you do for public optics is to be infringing on people's rights.
Listen, I'm speaking about this generally. That I don't think that even in terms of the work of the committee, we can criticize or we can look at what they were doing as a group of individuals that were working with the president-elect. That I don't think was appropriate because it makes a mockery of it. And particularly when there are concerns as to whether or not there was going to be a witch hunting that this entails, that invitation of the media and doing that public tour was completely unnecessary. And there's a risk of caricature. And that's kind of what I felt was going on, that, you know what, it detracts from the seriousness of the fight for oral. I mean, I have been a strong public advocate of oral because I believe that people need to be held accountable for that. But I don't endorse. It's not a belief that we have to suspend law to achieve justice.
Okay.
You know what I mean?
So back to oral. I've been reading your posts from X to Facebook. In fact, in particular, Facebook, I've been reading a lot from you. You see, you've been a strong advocate for oral.
Yeah.
And also, I think, in effect, supporting the reset in that regard.
Yeah.
Because you claim you are a CPP person.
Yeah.
As to where you're...
I'm on the left. I mean, I'm not bound to the CPP.
Oh, but you mentioned that when you were at Parliament.
Yes, I'm politically affiliated with the CPP. But
maybe you don't have a card.
Intellectual.
You don't have a card to that effect. Yeah. Okay. Being a strong advocate of oral, the point is, for me, as a believer in our democracy, the law must apply to everyone, whether it is convenient to you or not.
I completely agree.
You don't apply the law when it is only convenient or inconvenient to another person.
Absolutely.
Now you find the Attorney General withdrawing and dropping charges, filing nulli prosequi, including yours.
Yes.
But you are happy advocating that some people should be prosecuted.
Yes.
Why do you think that for Oliver, you in person, your charges should be dropped?
Yeah.
When we all saw on television that you were demonstrating, I agree with you, that is your right, but you went ahead to even remove the key from the ignition of a police vehicle. For you should be pardoned and others should be prosecuted.
So let's be clear, because one of the things that when we fail to do, we decontextualize conversations. We run the risk of reducing the conversation to absurdity. Okay? So I was arrested in 2022. Okay, initially charged with a misdemeanor of what do they call it? Breach of peace, whatever it is. And then on the day of court, it turns into a treason charge. And for 2 years or 3 years, I was held by the Republic on a treason charge, for which my passport was seized. Okay. At no point within those 3 years was any evidence presented to court. In fact, the trial never started. No matter how much we press them. In fact, for them to take any action would apply to the Supreme Court to quash, then they'll come and file one process. And this was held on for 3 years.
You went through Komitao.
You understand? Yes, we went through Komitao. I mean, the Komitao just said, I mean, I am essentially bound to commit. Okay? Now, all this happens. So many people have spoken against the weaponizing of law to be able to target political dissent or political dissidents, right? And an Attorney General comes in and said, I've reviewed the case, calls me even personally and apologizes on behalf of the Republic. Said, I've reviewed the case and there was no basis for the Republic to do so. And we say that because the Attorney General is interested in oral, he must keep going cases on things that have been done to violate human rights. Would that be the case?
Please let me hold you up here. In your case, was it a nolli prosequal or in the same nolli prosequal regime by the AG, the current AG? We heard the AG at a presser telling us that he contacted the lawyers of the Assent North MP. I want to set the basis.
I know that. I'll come to that. Because you gave me a litany of cases, and I've talked about myself personally because you put that in there. Now, the fact that, and if we can agree on this, that an Attorney General is not bound by prosecutorial misconduct of a previous regime just because they are interested in the proper rule of law or proper due diligence in respect of or prosecuting officials that have been involved in cases. There's no equivalence that can be drawn that unless you keep old cases going, you cannot be interested in new cases. I don't think
that is not that argument.
No,
that is not the
Then Attorney General then goes on and says that they were withdrawing the charges against some of those who were involved in settlement, right? And then says in the case of the decision about the Assent North MP.
Yes.
Okay.
And the governor of Bank of Ghana.
Yes.
He was deputy then.
Yes. Okay.
For his
now let's take the Assent North MP. I completely agree that the decision to whether or not to file a no prosequa is the Attorney General's ethical duty to make on the basis of what is before him. In that decision-making process, he cannot subject his reasoning to the pleasure of the lawyer of an accused person, whether or not the case will go on. As a lawyer of an accused person, that's not a call I would make. That no, the Attorney General should not suspend. And if the Attorney General tells us that the reason why he refused to exercise his nolli prosequi powers is because somebody has suggested otherwise to him, then he had acted in violation of Article 296. That is a conversation we can have. The fact that the Attorney General even issued a nolli prosequi in my case, despite my sincere belief and so many other people, that the charges were trumped-up charges, a person is entitled to agree or disagree with him. This is why I strongly believe that the Attorney General coming to the public and announcing this draft decisions is going to be taken is in the interest of our democracy. Because you and I, they can scrutinize the reasoning behind it. We wouldn't have known that he had a previous conversation with the lawyer on Assent North and decided not to, right? So it's for the health of our democracy that that they present their reasoning to us and then we can then question or approve of it. In the same regard, for instance, in the decision to drop charges against Alaji, I've forgotten his name now, on the course of Saglime.
Collins
Dauda, right? I've seen Manasseh, for instance, talk severally about why he disagrees with that decision. For instance, we had mobilized then, when the current government was in opposition, we had mobilized people to occupy Saglime for the failure to put it to good public use. You know, we had explored with several lawyers as to what standing we may have if we wanted to take the government on it. So that's not something that I disagree or I agree with, that it shouldn't be scrutinized. Sweeping it under the carpet does not allow us to properly record what happened in connection with Saglime.
Because one of the reasons he gave in Saglime is that the former minister, the Honorable Samuel Atachia, made some payment. So I had an interview, a conversation with him, and he said, if I made some payment, why don't you even join me today? And
I completely agree. That's what I'm saying. So the fact that he has taken those decisions and presented this to the public invites the kinds of scrutiny that we are doing. Now let's be careful that we do not then subject, that we may feel that the Attorney General may have gotten something wrong, to say that the commitment of the Republic to recover prosecution or loot or corruption should then not go ahead or should be hampered by the fact that we disagree with him on a decision he has taken before. That I am able to dissociate them. You understand what I mean? In the same connection that I constantly criticize the Attorney General on the lack of pace on oral. Right? I don't say that because you gave me nolli prosequi, so I'm not going to be constantly on your back, on your neck. No. If that was the case, I wouldn't be doing the kind of work I do. In fact, even when the former Attorney General was in office, a lot of people had called on him to file nolli prosequi in my case. I publicly said I was not interested, because I wanted them to carry the shame and burden of what they had done.
Shame embedded.
Yes, you understand?
Because they've not filed evidence or abuse evidence.
Because it is a question of the immorality to which we're putting the Republic. I think that the decision to charge a person is such a solemn duty that you must reflect on it and not do it for political reasons. I thought that what led the thinking on those were political reasons. Now you talk, for instance, about the other case, which is the case of taking a key from the for police vehicles.
Yes.
Now let's be clear, particularly because you're also a person who was of legal learning.
Yes.
That we don't miseducate the public. That the mere fact that an individual demobilizes a police vehicle is not a crime. Absolutely.
But you are obstructing their duty. And
be careful.
You are obstructing
be careful.
their duty.
To be able to get to that conclusion, you must first conclude for yourself that the duty that being exercised is lawful. Okay? So, a police officer in exercise of unlawful duty must be stopped. That's what the court say. And Asante versus the Republic, what does the court say? If you're putting somebody on an unlawful arrest, the person is entitled to beat you up. And that's what the person did.
To beat you up is outrageous.
No, but what is what Asante did? He beat you. The resistance is to beat you up. Okay. So there are individuals involved. I'm even lucky that I didn't run them up and beat them up. Because in the particular circumstance, and I sincerely have defended that I will do it today and I'll do it again. In fact, I was reflecting in that moment whether or not to drive away the vehicle. And I decided that the more better ways to try to demobilize the vehicle in that moment. Are
you saying that the police were unlawfully arresting you?
That they were unlawfully confiscating the property. Think about the criminal law, right? Even the right to search a person or anything is consequent upon arrest, not before. You can't search a person without first arresting them. In the same way, you cannot confiscate property.
You can actually search when you enter, say, I want to arrest you. You
must first make the arrest.
When you enter a building, I am allowed to search the building.
No, listen. You cannot just enter any building without first arrest.
But when I have reasonable suspicion that you are running away from arrest and you've entered this building, I can enter.
So what you are doing is that the reasonable suspicion is based on commission of crime by an individual.
Yes.
An attempt to arrest first has to be made, and the person who has not submitted to arrest. It doesn't mean that when the person fails to submit to arrest, and then I see that the murder weapon is on the ground, I said, because we couldn't catch him and he ran away, I can't pick up the murder weapon. You understand? So in terms of law, all of us were standing there. The police debarks, bring a towing vehicle and starts taking away private property. You're entitled to resist the police in that unlawful duty.
Weren't those properties being a stumbling block on a road that leads to a measure of error?
You see, this is where the responsibility to educate the public is important. Because the vehicle was nowhere near a public vehicle.
No, the vehicle is fair enough. But you had placed stumbling blocks in the road. You agree with me. And so to get you to move your things out, let's pick this because it's also a police strategy.
I don't think you are correct on the facts.
Okay, so probably
there's no blocks that were put in.
There were blocks. You had blocked the main road.
No, you see, you're confusing two things. You're confusing the events of the first day and the events of the second day.
Okay.
So the events of the second day, in the space in which you are protesting, there's nothing stopping you where you are protesting, whether or not you want to put a tree house or stay in there. So in the first day, within the space in which we were doing, in order to protect life and property, we decided then to make a block. In fact, it was the police's duty to do that. But they refused under law to give us the protection from traffic that was required. So then we had to make sure that, okay, we've brought people out to protest. And so we're ensuring that the people don't get injured because vehicles were being waved to pass through where persons were protesting. You see? Now, in that day, in that moment, the police did not think then that there was an arrest was needed. They came the next day in order to break apart the protest, saw a vehicle which was being parked under a tree and decided for themselves that they wanted to pick away the vehicle. That's what was being stopped. But again, not to go into distances, like I'm saying, like whether you have a right to disagree on that and I have a right to think that the Attorney General was proper, not to take that forward. First thing you must first, even before that, the then Attorney General did not even file charges. First, they brought a charge sheet that said they were charging me with stealing. But the second charge sheet, they had dropped that charge because they realized it didn't make sense. So there was no crime that because you saw me demobilize a police vehicle, it should stop oral.
I get you. So you back to why we need constitutional amendments.
Yeah.
I believe you have a plethora of constitutional provisions, but I want you to talk about two.
Yeah.
Article 60 and Article 146. Okay. I don't know which one you want to take first. 60 because of the current issues of the president outside the country, the vice president out, the speaker out. Is there a power vacuum?
So you see, some of the time, one of the reasons why I think that our constitution is completely bogus. It just reminds me of that Alan Barnes constitution.
But bogus is a strong word.
People call it bogus at birth. Is that the constitution is based on certain assumptions that are laughable in a modern republic. Okay, so like the example you gave, right? The reasoning behind why we have done that is because Nkrumah flew out to Hanoi and for which reason, then we decided that when the president is outside of the country, he can no longer exercise the functions of his office. It's completely a fallacy. Not in today's world.
To say that is a complete fallacy would not be fair to the issues that were happening from 1966 forward. Maybe now it is not useful.
That's what I'm saying. But let's be clear. We only have an example of a president who was outside of the country when he was overthrown, right? All the other times that we have had a coup d'etat, presidents were actually in country. Our head of state was in country. Okay. So based on that reasoning, we decided that, okay, if you're outside of the country, you're not an executive authority, and for which reason, you have to swear people down the line. In other places, it's more solemn a duty. That unless that would only be exercised where the person was immobilized, physically unable to perform the functions of the office, then you swear an oath. Maybe the president is in coma or things like that. I don't think that those arise. It just comes from a reactionary constitutionalism or constitutional making. That sort of reaction, it also underpins why we have a hybrid parliamentary system. Because a parliament rejected Liman's budget, we decided, why must parliament reject the budget? So let's make sure the ministers are from parliament. And it makes mockery of the fact that parliament holds the power of the purse. They decide whether or not the executive can spend or not. So in fact, parliament is working in the way where democracy is supposed to work. But we then created a constitution to block them. And then later on now cry that parliament is so weak. You see what I mean by, the assumptions that underlie how we make constitutions.
So what do you propose?
60, I propose, my thinking is that that executive authority is not extinguished by presence within or outside of the jurisdiction.
Okay.
And so as long as the president is somewhere acting, exercising executive authority and foreign travel, then he's fine to be able to act. We may have a question where the president is outside but on vacation. Okay? That is a nuance that we may have to reflect on, where he's in a situation whereby he is not exercising executive authority. But then even in those instances, we do have the president travel with bodyguard and trappings of executive power. So what about that? When the president is there, can he have a phone call and a conversation and represent to another head of state while on vacation even? But the person, a public officer who is on leave, does not cease to be a public officer. So these are questions that we need to have conversations about. Because let's say the acting president in country decides to close the airspace so that the president out does not return. Does he have the executive authority to do that? These are questions that we are essentially putting our hands in somebody's a beast's mouth, because the scope of what the president can do while sworn in as in within country, he must act as president.
Sure.
So yeah, I think that these are things that can be reflected on more generally. Article 146,
yes,
which is in terms of the removal of people within the judiciary and also heads of independent constitutional bodies. First of all, 146 was not intended to apply to Shraj and all those bodies, because we ended up with no provision on them. So we're like, let us treat them as we treat judges. But then, one of the things that I say about our legalizing of so many things is reflected in 146. So for instance, let's talk about the process for removal of the Chief Justice, for instance. We have a process that says you have 2 judges of the Supreme Court and 3 persons who are non-lawyers, who are not part of the Council of State and who are not judges.
And not even MPs.
And not MPs. The implication thereof being that we are looking for lay people, right, in legal sense, to be on the committee. So this is not a legal process. First of all, you go about, then you task the Council of State, which is a non-legal body, to go and find a prima facie case, a legal standard, right? It's not immediately intuitive what they're supposed to be doing.
But a former Chief Justice is on the Council of State to help.
So the Council of State acts as a collective. You can't. It's not the Council. The former Chief Justice acting as an individual. It's not a. You're not supposed to sublet the reasoning and mind of the council to one person. That's not the intendment. If that becomes the intendment, then we have failed.
Sure.
Okay. So it's to have the benefit of the collective. That's why we have put them there. So we have to be able to rethink. Okay, when you're inviting them to do a non-legal exercise, can non-legal people know morality when they see one? Can they see misbehavior when they see one? If so, can we express it in non-legal standards? That's one thing. The second thing is that one of the things that passionately disagree about is that the process has to be in camera. I think that it weakens our democracy for Ghanaians to wake up.
Have you considered the fact that someone has alleged that on one of the grounds, the Chief Justice is having, say, an infirmity of mind or body, and you want that process to come out?
Yes. Yes.
Okay.
I mean, listen, it says that the Chief Justice, infirmity of body or mind, the Chief Justice is unwell and cannot exercise the functions of the power. You don't think that the public is interested to know whether or not a sane or insane person is in office? And you don't think that they're entitled to know whether, in terms of the process, that the person clearly is not insane and is shown to be mentally competent?
You are also not considering the fact that, say, if he's indeed insane, after the process too, there is a stigma and others.
The person is insane. We have removed the person for being insane. We are worried about stigma. I mean, we have already been removed. Yes. You see? The public, listen, the Chief Justice is not the President's Chief Justice.
Okay, it's the People's Chief Justice.
It's the People's Chief Justice. The people are entitled to know that the person who is in office is competent to perform and that their removal is fair. I think it undermines our democracy for people to believe that the President cooked up a process, held some process that we don't know what happened there. And then we wake up one fine morning and Felix Ofochukwachi has announced to us that Chief Justice has been removed. It creates a sense of politicization. But if we're all going to see it in the same way of you and I were not there, sort of the televised presidential elections thing,
2030.
right? It creates a sense, we all see the process that is going on. We can then be convinced that, you know what, fairly, the person has gotten their day in court. You know, so I don't like the reasoning behind making it in camera. The process of filtering spurious allegations, like allegations without merit, is what the initial scrutiny stage does, so that we cannot say that, well, what if it's not fairly accused? Well, the filtering process does that. Now that they're telling that there's a basis to inquire, let us all see what is happening. You know, democracy dies in darkness. You know, so more sunshine, I think, is believed. That's also the reason, and I apply to why I think the Attorney General is entitled to inform us. We have people of sense. Let us treat the Ghanaian as a person of sense that can also look and make the comment. Let us not make these things the exclusive of a lawyer and subject the entire nation to what lawyers go and believe and do and come and present to the public. No, we undermine our democracy by putting lawyers in a position of ruling over us.
Very, very well. So other constitutional provisions you think these are...
So this is one of the big things that I tend to avoid in the conversation around constitutional reform. Because it's a myopic view to select constitutional provisions. We must think of framework. We must reflect on what is the framework we want executive power to look like, and then treat the conversation more holistically. You know, but if we take it article by article, then we've missed the point. For example, if you take chapter 25 of the Constitution, you can only go into the Constitution to amend existing articles. Can you introduce a new article?
No.
So that is the poverty of reasoning, right? It stifles a creative imagination about in what direction we want to move the Constitution. And we are then bound and our hands are tied by what has already been created for before. So that's one of the things that, okay, let's act as if the Constitution was not there.
Okay.
What document would we design for the people? That's one of the things. So if you ask me, my feeling is that the Constitution was based on certain assumptions. The assumption that institutions would keep our democracy in safeguard. You know what politicians discovered? It is easier to capture the institutions, appoint political hacks to those institutions, then they lose their voice. Then the people then are left out of the process. So you and I, for instance, disagreeing on the Attorney General's prosecutorial powers, for instance, now, what can we do? We are then stuck. But what if we allow private prosecutions, as exists in other democracy? You and I then, who believe that Saglemanese people need to be held accountable for it, we mobilize ourselves, we mobilize resources, and then we prosecute the individuals there. We subpoena for the records and prosecute them. We used to have this in our law that was taken away, private prosecution.
Okay.
You know? So my thing is that our constitutions must be reviewed in a way that allows the people to get around when the institutions are not working. And what does that look like? I'll then introduce a number of things. For instance, there must be a right of recall of people when you elect them. So elected officials should be able to collect a number of signatures. When we have sent them, they realize that they are not doing the job, to demand a recall election. You know? I must think about, for instance, when you take, say, the judiciary even. If people have lost faith in the judiciary, okay, how do we ensure that people are represented in the judiciary? I'm a strong believer in the jury system. I'm a strong believer in the public tribunals, because justice must be administered in their name. You understand? And
public tribunal.
Yes. The public tribunals come from the same stock of thinking as the jury system. That is not that people who are trained in law are the only repository of what justice looks like. That the people who own the justice can then come in and listen and judge their peers. You understand? So any process that we go through that demystifies and doesn't make justice an exclusive of lawyers, I am absolutely awful.
So even with public tribunals, if you look at our history with regards to public tribunals, you know, it is not a good one. Do you
I don't necessarily agree.
Because you see, when you look at our Evidence Act, NRCD 323, and you are looking at section 51 and 52, you see, when you read, it is quite a funny provision. It says that irrelevant evidence don't admit. Relevant evidence admit. Even with the relevant evidence, you have about 3 options to check and filter it. You don't think that people who do not really understand these legal underpinnings are so let's even pick some are likely to just board things off and get people prosecuted, put them in jail.
You know what I hear?
You see, Oliver, I'm coming. If you look at our political system, Article 19(2)(c) is so clear. Presume someone innocent until the person has pleaded or proven guilty. In our political dispensation, you agree with me that we rather presume people guilty until they come and look for innocence or prove themselves as innocent. And you don't think having these people who do not really understand the legal basis and looking at our history once again is going to affect our prosecutorial or our criminal jurisprudence, sort of.
Well, let me tell you something though. One of the things I find quite interesting, 2 things. One, you have a funny way of asking a question when you say, would you agree with me that? So that I'm then placed in the box to go and be following you. No. And then the second thing is that you are a victim of your legal training. Because when people go to law school, it impoverishes them rather than enriches them. The reason is that once you get in there, they tell you that forget everything that you know. Everything else you know is sociology. And then we then take your mind and say that this is tabula rasa. We have cleaned you of all the things that have made you who you are, and that we then have to brain wash you into some thinking. You have to give me an example of like the Evidence Act and certain things about relevant evidence and non-relevant evidence. Anytime I go to court, the judges say every evidence is relevant evidence. Those who have gone through this training that they tell you think that allows them to filter evidence, I've come up with this reason. For which reason? Evidence that is illegally acquired. Evidence that breaches the constitutional protections to privacy. We say that we still admit it. So even when the constitution has been breached, your trained judges look at it and say, we'll take it. Even when a person says that I wasn't present during the search, and then somebody comes and says, this is what I went to find. Illegal search, where we have no way of determining whether or not it was planted. We say that, no, we'll still admit it.
They don't admit it wholly.
Don't admit it completely. He says that I'm going to assess it in terms of weight. I beg you. What are we talking about? So there's a lot, in many other democracies, there's a lot that has been done that shows that law school doesn't make you superior in any way. You're not cured of biases. You're not cured of impoverished thinking. All the things that we claim now are old, that we look on and say that it was bad law, it was the trained judges made those that we today are calling bad law. You understand? So it is important that we don't feel that particular kind of training better entitles you to better do justice. I don't think so. Now, you mentioned our history. And I agree that the public tribunals suffer from the baggage of history. In that because it was instituted during a military era, we assume then that everything then is not kosher. I don't necessarily agree. The fact that the public tribunal exists does not mean that due process cannot be ensured. Removal of a chief justice. The majority of the people who form the committee are lay people. If at the highest levels of office we think that it is fine for lay people to be involved in the process, then what is so different about the public tribunal system? So again, history is talked about in a way, and I understand the emotiveness that some of these things raise, that disables us from being analytical. And I'm more about, okay, wait a minute. What is the concern? Due process. Are we saying that we cannot design a system that guarantees due process?
We can. So if you agree that we can, then you shouldn't be saying that the law school itself makes you impoverished.
Oh, it impoverishes you because
maybe our laws are
vision.
quite obsolete now.
Because and our legal training is as well.
So where JSC tells us one thing, I like that quote in the Tufo and Attorney General.
You see, that's one of the dogma that you have carried on every time.
You should
be talking about it doesn't mean anything.
So if in 79 we are making a provision that was based on the circumstances over there, maybe we should consider an amendment that at a certain point in time, because in 79 we had no X. In 79 there was no social media. So maybe the laws might not have considered all those factors. So if we grow, then it is quite important but to say that the legal process makes it.
One of the questions I remember at graduate school, it was being asked consistently is the Constitution a suicide pact? Okay? Or is it just a guide? Is the Constitution a suicide pact? Which means that a suicide pact means that we must abide by it even till death. What the Constitution has provided for.
The Constitution itself does not say so, because there's an amendment.
And if it is a guide only, then it means that every time we read it, we just, it's a broad guide. It's not supposed to be followed to the letter, because it's supposed to guide us. This is a tension that we're constantly always having to deal with. So, for instance, when you think about Archer in MPP, Archer says that, where is the spirit? Show me the spirit. It's because of the license that people are able to give themselves and say that I am following a particular spirit, and I'm following a particular purpose, and then start going on the frolic of their own, that you can take a Supreme Court decision now, two people will tell you that they are following a purpose of the Constitution, giving, know that everybody's going in a different direction and disagreeing, in fact, on the same panel. We must admit that certain things that we have now reified as if it is wisdom, we don't know what we are doing. Everybody brings their own politics to it. And so I am more for a system that says that these are my politics. My politics that I am a left-leaning intellectual. I believe in the people's power. I am against elites in society. And I disagree with the consolidation of elite power in individuals. Anytime before a constitution, I ask myself, does it strengthen the people against the elite, or it strengthens the elites against the people? This is how and I will be clear to you that this is my reasoning and how I view it. If you are taking me on as a judge, you know where my politics lie and how I view law. I am not coming to lie to you that law is something that is so removed from me that I have just gone to carry and given, like it's such a objective process. It's not objective. Law has never been. That's why we are not better at it than those who are untrained. So every time when we are functioning in society, I want to think, okay, is this a progressive bench? And if I cannot get progressivism from lawyers, I look for that progressivism from a political scientist, from anybody who is in the farm, cocoa farm, who believes that the state does not have the power to monopolize the proceeds of cocoa. Right? Legal training does not give you the tools to be able to decipher whether or not the Ghana Cocoa Board, which has a monopoly over cocoa, is fair. I don't believe this. I think that a state-driven monopoly weakens the people against them. You see? So these are the reasoning. There has to be some bigger philosophy that drives the person. But law school doesn't give you that.
President Mahama is offering all of us the opportunity for a constitutional amendment.
Yes.
A constitution, this constitution, 1992, can be entirely changed through this process. You agree with me? If we are doing a total overhaul, considering chapter 25, if we decide that, okay, we are subjecting all entrenched provisions to the voting, the whole criteria whatsoever, and we vote, and we tend to move to parliament to do all the people call it enshrined provisions and others, we can have a new constitution and your proposals.
I don't agree.
You don't agree?
Yes. Do you know why?
Why?
You take Article 60. Let's say that 70% of Ghanaians believe in Article 61, but disagree with Article 62. Okay? Then you go and rewrite Article 60 completely, and you bring it to me that go and do a yes or no. Am I entitled to be consulted on every individual one? The process by it, what is the constitutional entitlement? That any change must be of an entrenched provision must be subjected to the people. So can you then present a package deal? If you take either all the provisions changed at once, or one article, everything changed within. You see, it raises questions.
Let's even assume that we are doing it a clause by clause.
Yeah.
You don't think we can agree that we should all change all?
Oh, if we do a clause by clause, let's say of 296, All of them. Mean that we will line up
299.
299. We line up and vote for everyone 299 times. It still leaves the question: what if you want to introduce a new thing? And I don't want to amend.
Okay.
I don't want to. What I want to introduce is 300. You cannot introduce Article 300.
So, but the new things can be embedded in there.
No, but I want Article 300. Because the new things must follow the logic of what exists. Right? Like if you are putting a provision on executive power, the things that are related there must follow executive power. You can't then dare say school children must eat 2 breakfasts. You see? So, again, the procedural difficulties in terms of an holistic review. And in fact, as they are there now, I have gone before the committee and engaged the committee.
Yes, okay? I saw that.
And it's important that nobody even knows for sure that they're going to be able to get this through. Maybe Parliament, they might for the non-entrenched, but for the entrenched provisions, to get the numbers, the thinking is that they're going to tie it together with presidential elections because Ghanaians are excited about presidential elections. So that people come out and vote and then be forced to vote for another one. You see? So there are procedural challenges that is making them think, okay, we don't know how to present it to the people. How many can we give them at a time? And so let us then shift through and then do a few ones. That process that is tied into the procedural question of how you can get the people to come and vote for so many times means that you're going to prioritize and deprioritize others. Not necessarily out of a conviction of whether or not it is good or bad, but just that how is it possible to get people to come and vote plenty times?
So,
you know?
So
those decision makings take away from it.
Creating a new provision in the Constitution obviously is difficult.
Yeah.
Why does an act of Parliament not suffice for that? Must it necessarily be in the Constitution to have a force of law?
Yeah. No, not necessarily. It can even be made by a chief. It becomes customary law, right? You agree? So that's not a question. The question is whether or not, why do we put things in the Constitution? We put them because they become the foundation and they structure the state. Okay? An act of Parliament does not as much have a structural impact of the state because of the ease of taking away. It's like we have created all these things, Heritage Fund, all of these things. We said, oh, Ghana has gotten oil, we're going to look like Norway. And then we started, and if it doesn't, it's inconvenient, we go and change it, kakra. So
now we look like what?
you tell me. So, I mean, there's a limit. So there's a reason why we do constitutions. If not, then we just forget the constitution and do everything by act. You know, but yeah. I think that for me, it's really about the structure of governance, really. It's about the vesting of, you know, the idea of vesting of our resources in the president, but we're in the trust. But then we as trust beneficiaries cannot go and enforce the trust in the Constitution. Like there's so many things that for me that, like I'm telling you, filtering through the prism of does this empower the people or the elite? I realize that if the people have no mechanism to hold you accountable around certain things, then what have we created? We've created a monster. You know?
Right.
And the state is always an inconvenience, not a pleasure.
The time is fast spent.
I understand.
So, obviously, there is a problem introducing a new provision and probably changing the whole framework of our Constitution.
Yeah.
Is it why you have a pattern of writing on Facebook that, on my way, Ajiku. and you even ended up recently deleting one?
No,
but
people went around claiming that I deleted it, but it's still on my social media.
Oh, okay.
I just saw that and I just laughed over it.
Okay.
But do I believe that the Fourth Republic is fundamentally flawed? Yes. Do I believe that, you know, the mechanism for reforming the Fourth Republic, I'm not seeing it clear? Yes.
So there must
but
be
I don't believe in the coup d'etat.
But you've been writing about it.
No, I'll tell you why. First of all, I thought it very funny that when we started our advocacy, you know, the Interior Minister went to Parliament to say that we are operating with a coup d'etat mindset. The now deceased...
This current Interior Minister?
No, the former Interior Minister then.
That is Ambrose Derry?
Yes, Ambrose Derry. The now deceased, the former Deputy Finance Minister, John Kuma, said that terrorists had hijacked the country. And one of the things I came to realize in terms of the elite verbiage was that they were bringing up these ideas of coup to discourage a conversation about the limits of power and whether or not the Republic was serving Ghanaians. So I started then making a mockery of it because it seems that they're not afraid of our demands and our cries for hunger. They're afraid of losing power. So it is satire. It's a mockery of the system that has become so fixated on coup rather than solving the people's problems. You understand? So every time I write this, I realize that elites are uncomfortable. Do you know how I realized this? When we're doing advocacy and then a coup d'etat happened in Guinea, and I welcomed the coup in Guinea. You should have seen my inbox from members of parliament, ministers, everybody. I'm like, and I just kind of realized that the political elite do not care two hoots about us. They're only worried about losing power. A coup makes them lose power. So I started teasing the political system and the elite structure we have created. So every time that the political elite misbehave, I write Ajiku as a mockery of the system.
You see,
but I am a person who, from a conversation around constitutional reform, has always been clear that it is to improve the democracy. That we as citizens in the Fourth Republic can, through democratic means, change the rules of the game. And anybody who says that they cannot change is impossible through democratic means is only inviting chaos. You understand? So I speak as a true believer of democracy. There's nothing in me that suggests. But people fail to understand that even aggressive mockery of a democracy is self-democratic.
You see, in communication, I believe you know that. Encoding and decoding information, there is a gap between that. Because when you say Omai Ajiku, and you are making fun of it, someone somewhere in my village, Ekwiyase, in the eastern region, recited here coup. The person might be some 70 years, 80 years, had suffered through the Rawlins's time and others. You don't think, you are not even causing fear and panic, but you are adding to their illness.
Let me give you an example. That the democracy we have has created as much bitter memories for people as non-democratic eras. There are people who have lost their mothers in hospitals that we couldn't provide them health care. We have to put up the lights go off and people die.
Coup does not also
hold on. That's not what I'm saying. You are mistaking again what I'm saying. That they have bitter memories of the democracy as well. So when I stand on the platform and I say that Fourth Republic and one echo, are they entitled to have the same thing that somebody in your village at 70 years old has as well? I don't necessarily think so, right? So for me, I have been clear. If you say you misunderstood or not understand why we're asking or calling for coup, it has been clear enough for you to understand. And if you don't, I mean, I can only explain. But it's an intellectual opposition to the politics of the Fourth Republic, and I can only be clear on that. And in any event, before we end, I'm a person who will not survive in the system that does not allow dissent. I am a big believer in the right to disagree. And if the political system is constructed that does not allow disagreement, then it's not the one that I would recommend for us as a people.
Sure. Oliver, thank you. Thank you for having me on the Law Lab. We will be coming again. This video has been proudly sponsored by Vian's Groceries. And as always been saying, do not leave all your matters to God. Take some to your lawyer. Maybe not Oliver. Thank you.